Good morning, wonderful people. This is Chris for the Informed Stoner. Today's Wednesday, the 22nd of February, 2023, and time for our morning news segment. Today's morning news segment is brought to us by CNBC.com. Supreme Court Justice voiced hesitation on Tuesday about upending a key legal shield that protects tech companies from liabilities for their user posts, and for how the companies moderate messages on their sites. Justices across the ideological spectrum expressed concerns with the breaking the delicate balance set by Section 230 of the Communications Decency Act as they ruled for the pivotal case of Gonzalez v. Google. Even as some suggested, a narrow reading of the liability shield could sometimes make sense. The current case was brought by the family of an American killed in 2015 terrorist attack in Paris. The petitioners argued that Google, through its subsidiary YouTube, violated the Anti-Terrorism Act by aiding and abetting ISIS, as it promoted the group's video through its recommended algorithm. Lower courts sided with Google, saying Section 230 protects the company from being held liable for third-party content posted on its service. Well, that's always a kind of dicey thing with 230, I guess. The whole liability, third-party content, I mean, should they be, should they not be? What do you guys think? Leave some comments. Let's talk about it. The petitioners contend that YouTube's recommendations actually constitute the company's own speech, which would fall outside the boundaries of liability shield. But the justice struggled to understand where the petitioners' counsel, Eric Schnapper, that's correct. Sorry. Was drawing the line on accounts and content created by YouTube itself. Conservative Justice Samuel Alito at one point said he was completely confused by the distinction Schnapper tried to draw between YouTube's own speech and that of a third party. Schnapper repeatedly pointed to the thumbnail image YouTube shows to users to display with the videos upcoming next, or suggested based on their views. He said that thumbnail was a joint creation between YouTube and the third party that posted the video, in this case ISIS, because YouTube contributes the URL. I mean, that's kind of a leap right there, but we'll see. But several justices questioned whether the argument would apply to any attempt to organize information from the internet, including a search engine result page. They expressed concern that such a broad interpretation could have far-reaching effects the High Court may not be prepared to predict. That's very true. I mean, you could imply a lot of stuff from that. Conservative Justice Brett Kavanaugh noted that the court had applied Section 230 consistently since its inception in the 1990s, and pointed to the amici briefs, AMCI, that warned overhauling the interpretation would cause massive economic consequences for many businesses, as well as their workers, consumers, and investors. Kavanaugh said those are serious concerns. Congress could consider if it sought to rework the statute, but the Supreme Court, he said, is not equipped to account for that. Okay, so he's kicking it back to Congress, is what he's thinking. You're asking us right now to make a very precise, predictive judgment that don't worry that it's really going to be that bad, Kavanaugh told U.S. Department Solicitor General Malcolm Stewart. Wow, that's a name and a title. Who was arguing the High Court should send the case back to the lower court for further consideration. I don't know that that's at all the case. I don't know how we can assess that in any meaningful way. A bunch of hoo-ha, who knows? I mean, they need to make a ruling. Either Congress does or they do. They need to figure this stuff out. When Stewart suggested that Congress could amend 230 to account for changes in the reality of the internet today, Chief Justice John Roberts pushed back, noting that Mickey suggests that if we wait for Congress to make that choice, the internet will be sunk. I mean, they might not be wrong. Congress can be slow on a lot of stuff. Even conservative Justice Clarence Thomas, who has openly written that the court should take up a case around Section 230, seems skeptical of the petitioner's line in the sand. Thomas noted that YouTube uses the same algorithm to recommend ISIS videos to users interested in that kind of content, as it uses to promote cooking videos to those interested in that subject. Plus, he said he sees those suggestions not affirmative not affirmative recommendations. Okay, so they're saying they use the same algorithm. Well, of course they do. I mean, it's YouTube. They use one algorithm. It's not going to have special algorithm for ISIS videos compared to cooking videos. It makes not much sense. I mean, I get that they should be promoting terrorist videos, but the algorithm isn't smart enough to pick that out. They're going to have people actually watch them. Should they? Maybe. I mean, that's another story. I don't understand how a neutral suggestion about something that you've expressed an interest in is aiding and abetting, Tom said. The justice had tough questions for Google too, wondering if the liability projections are quite as broad as the tech industry would like to believe. Liberal Justice Ketanji Brown Jackson, apologies, I don't know why all of a sudden I couldn't speak, but Mrs. Jackson, for example, had a long back and forth with Lisa Blight, counsel arguing on behalf of Google. Okay, that must be their lawyer or part of their counsel anyways. About whether YouTube would be protected by Section 230 in the hypothetical scenario in which the company promotes an ISIS video on the homepage if the box marks featured. Blatt said publishing a homepage is inherent to the operating of a website, so should be covered by Section 230, and the organization is a core function of the platform. So if the topic heading can't be covered, the statute basically becomes a dead letter. Liberal Justice Ilana Kagan suggested not necessarily to agree completely with the Google assessment of the fallout from altering 230 to fear the potential consequences. I do not have to accept all of Miss Blatt's "the sky is falling" stuff to accept something about, boy, there's a lot of uncertainty about going the way you would have us go. In part just because of the difficulty of drawing lines in this area. Kagan told Schnapper adding the job may be better suited for Congress. We're a court, we really don't know about these things. These are not like the 9 great experts on the internet. Well, I mean, they got a point. They're there to uphold law. I mean, I guess this kind of is law, obviously, but I don't know if it is their ball court. You know, maybe that is a congressional matter. Several experts rooting for Google's success in this case said they were more optimistic after the arguments than before as the press conference convened by the Chamber of Progress, a center-left industry group that Google and other major tech platforms support. Kathy Gellis is an independent attorney in San Francisco Bay Area who filed an amicus brief on behalf of the person running a Mastodon server, as well as Google-funded startup advocacy group and a digital think tank. She told CNBC that briefs like hers and others seem to be a big impact on court. It would appear that if nothing else, amicus counsel, I don't know why that word throws me, but for some reason it does. Not just myself, but my other colleagues may have saved the day, but it was evident that the justice took a lot of these lessons on board, Gellis said. And it appeared overall there's not a huge appetite to upend the internet. Well, no, nobody wants to upend the internet per se, but yeah, stuff does probably have to be a bit more law-abiding. I don't know, less crazy in some ways. I mean, it was always fun in the beginning with the lawless wild wild west internet, but you know, there's some crazy stuff that doesn't need to happen, that's for sure. Still, Eric Goldman, a professor of Santa Clara University School of Law, said while he felt more optimistic for the outcome of Gonzalez's case, he remains concerned for the future of Section 230. I remain petrified that the opinion is going to put all of us in unexpected circumstances. Well, it may very well put everybody in an unexpected circumstance. On Wednesday, the justice will hear a similar case with different legal questions. In Twitter v. Tamanay, the justice will similarly consider whether Twitter can be held liable for aiding and abetting under an anti-terrorism act, but in this case, the focus is on whether Twitter's decision to regularly remove terrorist posts means it had knowledge of such messages on its platform and should have taken more aggressive action against them. Okay, that's a question. Conservative Justice Amy Coney Barrett asked Schnapper how the decision in that case could impact the one in the Google matter. Schnapper said that if the court ruled against Tamanay, the Gonzalez counsel should be given the chance to amend their argument in a way that fits the standards set in the other case. Well, I don't know. I do know that 230 has been a hair up a lot of people's rear end for a long time now, and they need to figure it out one way or another. Um, this whole liability stuff, it's a slippery slope, and it's going to be pretty crazy. We'll see what happens though. But feel free to comment down below and let me know what you guys think about this. This is Chris for the Informed Stoner, and this has been our Wednesday morning news segment. Please feel free to join us Monday through Friday for news, entertainment,